thing is, it's only
Yeah,
the only
everybody
reason
give their views.
there's, it's
So that
very,
was good.
yeah, let's say,
You know, we
cost
got some.
sensitive. They want to do, they want to get, they want to do it,
Thank you.
they want to do it very
We
cheap.
got
Yeah,
some
so there's not really, you know,
Some of the comments.
there's not too much to get there, you know. When work
That's right.
for
And then
few
you've got to. We've got too many issues to attend to today. And economic substance and all these.
Yeah, yeah, yeah,
It
yeah,
didn't
yeah,
make any
yeah.
sense.
But yeah, are there going to be some slideshows program? What are we going to see? What's going to be? Is this what people are going to see on YouTube as well? This picture, this image? Well, we can check it out. I'm going to go over to the YouTube link now, just now to check it. 1 second. Over here. Well, I'm in Zoom, but I'll show you what people see in Zoom. On YouTube, they see this. Then we see everybody.
Okay.
That's them. That's what people see if they log into YouTube with the same link that was sent.
I would imagine so,
Everybody's sitting there. Okay. They don't see us yet. This is what people out of the meeting see.
Yeah.
And they can hear me. They can hear me. Sorry, guys. Well, we are already here. I see on YouTube a nice table with 8 people. I would like to greet everybody there as well. And we are ready to start. I don't know how. What are we waiting for? Can someone give us some highlights? Are we going to start? We are already here. I see on YouTube a nice table with.
Good morning, everyone. Good evening to some. Welcome. The Ministry of Finance, in collaboration with the Anguilla Commercial Registry, welcomes you to the first virtual consultation on the Anguilla Business Company legislation. Around the table, we have from the Financial Services Commission, the Director, Ms. Tina Bryan. We also have the Senior Legal Counsel, Ms. Fiona Murphy. We also have Ms. Sharonee Carty, Senior Regulator. From the Commercial Registry, we have Ms. Micheline Leader, Acting Deputy Registrar. From the Ministry of Finance, we have myself, Marisa Harding-Hodge, Principal Assistant Secretary Finance, and we have Ms. Marija Smith, Compliance Manager. We also have in the room with us the Acting Comptroller of the Inland Revenue Department, Mr. Lonnie Hobson. He's also the substantive post holder as Deputy Registrar of the Anguilla Commercial Registry. We have sitting with us as well Ms. Shernica Connor, Deputy Chief Executive Officer of Anguilla Finance Limited. And also we have Ms. Tira Green, our consultant drafter. Ms. Tira Green is an attorney at law and legal consultant. Her areas of expertise include legal gap analysis, legislative drafting, and legal and regulatory reform in the areas of ICT, trade, and digital transformation. Ms. Green has worked in the Caribbean, Africa, Pacific, and Asia on projects implemented by the Inter-American Development Bank, the European Union, Europe Aid, World Bank, OECS Commission, United Nations agencies, and the International Telecommunications Union. She has undertaken and led several regional and national assignments for the OECS and CARICOM member states, resulting in reforms in the ICT and commercial legal and regulatory frameworks. Ms. Green has also provided legal advice and legislative drafted services on the laws of CARICOM member states. She has drafted companies legislation in Trinidad and Tobago and Anguilla and provided advice to the registries of these nations. Virtually, we have industry members of the ABC Legislation Ad Hoc Committee. We have Mr. Ravi Battersingh. Mr. Ravi Battersingh is the principal at Chancery Lane Chambers, Barristers and Solicitors. He has over 20 years experience in corporate and commercial law and cross-border litigation. He has a special focus on the commercial and international regulatory aspects of distributed ledger technology and is the co-drafter of the Auto Act and Exchange Act in Anguilla. He also serves as the chairman of Anguilla Finance and is a member of the Joint Financial Services Legislation Committee. We also have Mr. Robert de Ruyter. Mr. Robert de Ruyter is the founder and owner of DR Asset Planning and has over 25 years of experience with various corporate service providers and trust companies. He is owner of DR Managers, a licensed company. Robert has specialized in tax law and is a member of the Societies and Tax Estate Practitioners, STEP. He has also served as honorary consul to the Kingdom of the Netherlands in southern Brazil. We also have Professor Alwyn de Cocker. Mr. Alwyn de Cocker is Professor Emeritus of Tax Law and Director of the Graduate Tax Program at the University of Witwatersrand, Johannesburg, and a member of the South African Institute of Chartered Accountants. He previously served as a professor at various law schools in the USA and conducted scholarly research on various international tax matters. He is the founder and owner of Concilium Limited and Geneva Trust Group of companies. He also serves as a director of offshore companies that are currently licensed under the Mutual Funds Act and Trusts Companies and Offshore Banking Act. In addition, we have Mrs. Joyce Kentish Egan, QC. Mrs. Kentish Egan has been a private legal practitioner in Anguilla and Antigua for 31 years. She was a founding partner with her late aunt, Dame Bernice Lake, QC, in the firm Lake and Kentish in Antigua and Anguilla, both firms being founded in 1987. The focus of the practice was commercial law, including litigation as well as banking, with a principal focus on securitization. In 2005, she fulfilled her delayed desire to be a full-time practitioner in her homeland, Anguilla. Home base therefore shifted from Antigua to Anguilla, and in 2006, she rebranded as Joyce Kentish and Associates. Mrs. Kentish Egan, QC, served for many years as president of the Anguilla Bar Association. Between 2014 and 2017, she exited active practice to become acting justice of appeal on the Court of Appeal of the Eastern Caribbean Supreme Court. She will tell you that the rigors of legal practice has taken its toll, but she would not have chosen a different career with all the hindsight it brings. Okay, so a comparative review was conducted by the drafter prior to drafting of the Anguilla Business Company legislation. A comparison was made of the legislation in BVI, Cayman, Jersey, and Singapore. Some of the findings of that review were that, 1, Anguilla has indeed not updated and modernized its company's law or introduced new vehicles in response to the demands of its potential clientele for some time. Other jurisdictions, such as Jersey, Cayman, and BVI, have been far more proactive. There needs to be a suite of legislation to be prepared if these objectives are met. An additional finding was that there was a need to strengthen specific areas as well as to include newer concepts and vehicles. Jurisdictions specialized in various areas, such as BVI in company formation, Cayman in investment business, Jersey in private wealth and offshore banking, and Singapore in variable capital companies, VCC. Anguillan companies were found to lack features which had to be incorporated into new legislations, such as the ability to be listed on leading stock exchanges, provisions for exempted companies limited by shares used for the establishment of open-ended investment funds, and provisions relating to variable capital companies and private trust companies. We also found that for Anguilla to be an attractive jurisdiction and to facilitate growth, there ought to be a legislative framework in place to allow for incorporations of various vehicles, which is the essence of a financial services sector. The comparative review influenced the policy directions and later then the drafting instructions to allow for a comprehensive and modernized piece of draft legislation that is before us today for consideration. By way of background, the Anguilla Business Company legislation, bills, and the regulations is part of an ongoing legislative reform to overhaul the Anguilla company regime framework. The Anguilla Business Company legislation will provide for a flexible companies regime that increases the type of legal structures that can be formed. The Anguilla Business Company Bill specifically allows for the incorporation of companies that can conduct business globally and or domestically in Anguilla while complying with international standards. That latter part is key. As you are aware, there was a need to modernize the company's legislations as no significant amendments were made except to meet international standards through the latter part of the years. Further, with the recent requirements by the EU regarding economic substance, this is indeed an opportune time to review and revise the company's legislation. The intention is to create a piece of legislation that is fit for purpose and adheres to international standards as well as competitive. As a result, the draft bill was put out for consultation in October of 2020, receiving various comments from individuals and organizations locally and internationally. It must be noted that the substantial comments were made by the Anguilla Compliance Association, Anguilla Finance Limited, Anguilla Financial Services Association, and the Society of Trust and Estate Practitioners, Anguilla Branch. An ad hoc committee was therefore formed to review the comments and provide responses, as well as to conduct further research in some instances. On the 1st of April, the draft regulations were published for consultation. On the 15th of April 2021, the second draft of the ABC bill was published for consultation along with the responses to the comments. On the 16th of April 2021, the second draft of the ABC regulations were put out for consultation. So as you see, it's been an ongoing consultative process that we put out the pieces of legislation for your feedback, we incorporate your feedback, and then we put it out again for more feedback. And this is how we intend to continue until this legislation is revised and refined to a piece of legal framework that is to the desires of both the government, the industry, and international standard setters. The ABC bill is intended to be the core legal structure for regulating the incorporation and operation of several types of companies. These include companies limited by shares, companies limited by guarantee not authorized to issue shares, companies limited by guarantee authorized to issue shares, unlimited companies authorized to issue shares, unlimited corporate companies not authorized to issue shares, restricted purpose companies, and segregated portfolio companies, SPCs, private limited companies, PVTs, which allows for a structure to be incorporated that is better suited to closely held operations such as family business and private trust companies, which conduct only trust business, that is connected trust business. Companies can also be incorporated as restricted purpose companies, which are typically companies limited by shares, but with clearly restricted objects or purposes. ABC regulations. The regulations are a key component to the ABC suite of legislation that is geared towards the update of the Anguillan company regime. The draft ABC regulations address the treatment of company names, including foreign character names, the reuse of company names, and restrictions impacting company names. Clear provisions for the incorporation or registration of an Anguillan company, a segregated portfolio company, SPC, as well as other requirements for SPCs are also captured within the draft regulations. Miscellaneous provisions set out key provisions for voluntary liquidations are also addressed. In addition, the draft ABC regs outline the fee structure developed through a focused benchmarking exercise for filings to be made under the ABC Act. At this time, I will pause for Ms. Tia Green, our drafter, to give a comparative review and overview of the ABC legislation.
Thank you very much. Well, I'll try because I think you covered it very much.
A bit lengthy.
Is the slide on? Yes. Okay. So, this exercise, I'm just going to go quickly first into the key concepts and methodology, and then I will go into one of the key features, which is the fully digital nature of the company's registration system, and which this new legislation also it was created to allow. So, as noted, one of the drivers, the rationale for this project is that, of course, Anguilla has not updated and modernized its company's laws or introduced any new vehicles for the past 15 years. We know that our competitor, inverted commas, jurisdictions such as Jersey, Caymans, and BVI have been far more proactive. And, of course, the recent amendments due to the EU initiative regarding economic substance means that, logically, there's no need to have two separate companies' regimes. So one must have the same standards applying to everyone. So accordingly, the idea was to consolidate and rationalize and modernize the two pieces of legislation to strengthen our regime and to apply some visionary thought and application. And part of that vision came because as well of the COVID situation. So while Anguilla is to be lauded as one of the most progressive jurisdictions in the world and the most progressive in the Caribbean in terms of having a fully digital registration system for 2 decades now, it is looking to move even further than that in terms of looking at having a legislative regime that reflects the digital reality, in looking at modernizing for smart contracts, clarifying that companies can enter into smart contracts to make sure that there's no doubt under the law. So this is where we have actually taken it further than what exists right now, say, than in the BVI. So, but when it comes to the substantive company provisions, we looked at the report by Capital Economics for BVI Financial. That report is creating global value, the BVI's global contribution. So I'll be the second slide, please. Yeah. Right. And this focused on why the BVI is considered a global leader in corporations of legal structures, even though we are aware that their dominance has been eroded in recent times. It does focus on the success and establishment of BVI as an international financial center. Now, upon analysis, we note that the Anguilla regime actually mirrors a lot of these strengths, and our company's law, a lot of the principles basically and provisions of our company's law are mirrored as well. What, however, is needed is strengthening in specific areas and, as noted in the first presentation, the inclusion of newer concepts and vehicles. Next slide. Some of the new vehicles we are looked at is that of the exempted companies. We know that Cayman incorporated companies are listed on major stock exchanges around the world, including the Hong Kong Stock Exchange, London Stock Exchange, NYSE, NASDAQ, and the Singapore Exchange. And there's growth in other locations such as the Taiwan Stock Exchange. All right, and this Cayman listed vehicle stock is the noted advantage is the flexibility of the law. And for example, the HKSE listing rules and ongoing requirements can be met because of this flexibility in the law. So this is why we have put in a specific part in our Anguilla legislation to also give us that advantage. Another concept we have looked at and attempted to incorporate is that of the private trust company. This is useful for wealth managers to offer clients the option of managing wealth through a PTC, which would then act as a trustee to a related trust as opposed to appointing a professional trustee. In our methodology, next slide please. In our methodology, the comparative report also considered the guidance given through the Financial Services Commission and the Ministry of Finance. Throughout this entire process, of course, we were guided by the committee, by the various industry players, the registered agents, the private practitioners. And we have completed several rounds of revisions, and we are, of course, open to doing another round or two of revisions until we are satisfied and happy with the final product. All right. As noted, our comparator jurisdictions include the BVI, Singapore, Jersey, and Cayman Islands. The new companies legislation features robustness, fluidity, modernity, visionary thought, and it further leverages advances in ICT. Next slide. Next slide. Okay. So this is part of the vision of the law. We are looking at regional and international trends. Now, the expectations of doing business, both of, say, the registered agent of a company and a member of the public, has changed, and there has been even more change due to the COVID pandemic. This has actually been a catalyst for further change, especially when it comes to digital transformation. So the expectation now is that you can do a lot of your business, if not all of your business, digitally. There has been a rush in terms of amendments to some laws internationally to allow for statutory declarations to be done online. And New Zealand was actually the first to do regulations or orders to allow this. The UK rushed through some emergency laws last year as well to allow for wills to be done, to be signed digitally, to allow for deeds to be signed and witnessed digitally, and a whole suite of things to be done electronically. The court, of course, a lot of the court in the UK have been conducted electronically for the past year, and some of it continues, a good chunk of it continues to do so. In the Caribbean and Trinidad and Tobago right now, almost all court is done electronically, and this has been so for a number of years. In Anguilla, we have been conducting court electronically part of the time as well during the past year. So this is what the customer, this is what your agent, and this is what a company that's incorporating expects to be done. They expect to be able to file all the documents, including notarized documents, electronically. They expect to be able to send an electronically notarized document as opposed to just a scan of a paper notarized document. They expect that they can have their annual general meetings electronically as well. So all those things were taken into consideration and put in the law to clarify that this is completely legal and valid. Right? There's also expectation for single windows. So right now in Anguilla, we do have like the Asicuda system, and there is a port community system or single window for trade in the works. So this law also looked at that to make sure that when that comes on stream, that this is going to be allowing, a company can do everything. So you will see that we made a note on smart contracts in the law to make sure that there is no doubt at all under our law that smart contracts and negotiable instruments can be signed, inverted commas, or executed by a company. Of course, as I noted, it is very laudable that Anguilla has its company registry completely online. The intellectual property registry has also been using digital technologies for a long time. The gazette, the publication of the patent and trademark notices have been done online in Anguilla for at least a decade, which is way before than most countries in the Caribbean have done it. Right? And the difference you will see in our law and regulations, and this is the first country in the Caribbean as well that has done that, you will see that we are not prescribing forms, and that is because even under our law, even under, if you look at the BVI law, the laws of most other countries, where you actually have an electronic registry, electronic system, they are still using a regulatory system that's meant for paper, meant for forms, where you normally go to the government printer, you print out from the regulation the form and fill it in and hand it in. And that has not been happening in Anguilla for at least a decade. So therefore, there is no reason to actually prescribe forms in a regulation, because none of the registered agents are actually going to be using that. They are going on the system and inputting data. All a form is data in a paper format. Therefore, there is absolutely no reason, if you're inputting data into a system, for you to actually have a form generated. So it's like the reverse engineering. So it's like you have rules for a horse and carriage, but you're driving with a car. And that is what has been happening in most of the regulations. So you will see that these regulations are modernized and are streamlined and are suited to the system that we do have and to the laws that we have today. Okay. Next slide. Okay. Right. So, of course, as we said, the use of electronics is ubiquitous. Next slide. Yeah. So I've spoken on the first two bullet points. I've also mentioned that the law clarifies the legality of smart contracts. And my last point is that in order to complement this, amendments to the Electronic Transactions Act to further enhance these provisions is recommended. Some of you may know that Singapore actually amended the Electronic Transactions Act in January, and it all came into force on March 18th or 19th. And that was in order to enable negotiable instruments to clarify the legality of smart contracts. And all this enables the use of distributed ledger technology in trade and in company contracts. So this is something that we are also looking at to move towards in Anguilla to complement the new financial regulations. Thank you.
So I will now just go into a brief background in relation to the kind of impetus for the need to overhaul the Anguilla companies regime. And as I would have mentioned earlier, one of the driving factors was international standards. Anguilla periodically undergoes reviews from international bodies, and recently Anguilla underwent in 2020, EOIR review by the Global Forum, at which it faced a rating downgrade due in part to deficiencies relating to the availability of ownership and accounting information of Anguillan entities. Much work has been done to improve the overall legal and regulatory framework. However, further work needed to be done to strengthen the provisions relating to the availability and access to accounting records, as well as the availability of ownership and identity information. The overhaul of the company's regime is a crucial part of this work. Now, as persons would be familiar with the economic substance requirements and the process surrounding that, in 2016, the European Union would have adopted criteria covering transparency, fair taxation, and anti-base erosion and profit shifting, against which countries were assessed during a screening process conducted by the Code of Conduct Group during 2017. Anguilla was screened during this process, and the COCG identified concerns that there was an absence of legal requirements for Anguillan entities doing business in and through Anguilla. Specifically, there was a requirement, and Anguilla legislated for, rules that will require entities registered in Anguilla that are conducting certain relevant activities and are not exempt entities to demonstrate that they are conducting real economic activity and have substantial presence in the jurisdiction. Relevant activities, as you would be familiar with, that are within scope are banking, insurance, fund management, financing, leasing, headquarters, shipping, intellectual property, distribution, service, center business, and holding company business. Now, whilst these requirements would have been incorporated into the IBC Act and the COC Act, this requirement to have substance did just further re-emphasize the need to really overhaul our company's legislation and combine those two structures. And these requirements have been transposed into the new ABC legislation. The economic substance requirements, as you would be familiar with, would have applied to new companies from incorporation in January 2019 and existing companies at that point from the 1st of July 2019. Another key part of this piece of legislation is the mandatory registration of directors and shareholders. As mentioned before, as part of the review process by the Global Forum, it was highlighted that there were some deficiencies in Anguilla being able to access ownership information, particularly as it related to struck-off companies and companies that were no longer active. So there's this mandatory registration of directors and shareholders. It's part of the process to ensure that legal ownership information is available for Anguillan corporate structures, and it is on keeping with the trend in other jurisdictions to ensure that these safeguards and these rules are in place to ensure the availability of certain identity information. Also, a key part of this process has been the regularization of the fee schedule for incorporating companies, registration of all companies, in this case the ABC, as well as the various filings as required under this legislation. Now, the proposed fees in the ABC regs for this new product have been twice consulted on, and this review process is ongoing by the ministry, and a crucial part of this review is comparing the proposed fee schedule with other comparable jurisdictions to ensure that Anguilla proposed fees are not only in line, but they're competitive. Particularly, we reviewed BVI, Cayman, Singapore, and Jersey. We feel confident that the proposed fees will be well received by the market. We have a new, well-fitting legislative framework for this corporate structure, and it is being incorporated and registered, and the filings are being conducted on a new system, which is up to date with modern technology. So when these factors are combined, we think that this is something that the market will readily accept and be pleased to market and promote Anguillan corporate structures. At this point, I will turn to Michelin Leader, Acting Deputy Registrar of the Commercial Registry. She's going to discuss the benefits and advantages of the proposed ABC legislation.
Thank you, Marissa. So at this time, I won't say a good morning or good evening. I'll just say a pleasant Thursday to whoever is listening right now. Some of us have been fortunate to be labeled as husbands and wives. We have moved from operating from a single-minded mentality to that of a union. This union brings together the best of both worlds. It helps to provide a more financial stability coupled with the fact that your ideas can become a reality sooner. This is how I view the combination of the IBC and the COC legislation. It's a sweet union. I believe that it was a careful, well thought out solution to that question we have asked: how can the financial industry grow in this economic downturn and still cater to the needs of the industry? The solution to that question is the enactment of the ABC legislation. It's a new piece of legislation, and I can envision the anxiety of some service providers, and on the other hand, the gleeful anticipation of others. Personally, I believe that change is an unavoidable part of the working life, and it's up to us to manage that change well. It will require a little more time to get familiar with the unfamiliar. For this reason, I believe we are here. The ongoing consultations provide you with the opportunity to be part of the end product, and I encourage you to do so. The ABC legislation affords you or providers with benefits such as: 1, as was mentioned, it combines the COC and the IBC Act. This simply means that we are not providing you with a skeleton. The contents of the ABC Act are not entirely new, and by now most of you can attest to that. There are many sections in the ABC Act that remains the same, with probably a pinch of salt here and there. For example, a company registered under the ABC Act can clearly specify from the get-go what type of company it is, merely by the incorporated name or by its abbreviated ending, whether it's unlimited, segregated portfolio, or a restricted purpose company, amongst others. Whereas with the current regimes, one cannot identify what type of company it is unless being privy to its articles. I should also interject that the ABC Act has allowed for registration of new vehicles, such as a segregated portfolio company. In addition to that, the combination of two legislation means that your entities are governed by one master, thus helping you to remain consistent and accurate when relaying information to your clients. You no longer have to wonder, is it a COC or maybe it's an IBC? This takes away that confusion. To me, in itself, it's also a benefit for the staff of the registry by having to use one act for our legislative queries. Second benefit, it has the same incorporation numbers. All companies that are migrated from Acorn will maintain its current registration number. We note the importance of this in more than one ways. This continuity is essential to avoid interruptions to our service providers and competent authorities. The aim of the ABC Act is not to give you undue stress, additional work, and loss of control, but for you to remain confident in managing and selling your offerings. However, all corporate vehicles that are registered on the new system will receive new numbers, and I believe that is expected. Third benefit, foreign characters and name. This benefit stems from what currently exists, but with a better face value. Agents can continue to start or extend their market to attract clients where English is not the predominant language. As it is now, agents can incorporate a company with foreign name, but will experience delays until the system is uploaded with the characters. The ABC Act provides for this process to be a seamless one, and such will be discussed further in our following meeting. Benefit number 4, the implementation of a company law review advisory committee. The introduction and the establishment of the Law Review Advisory Committee is highly significant to the industry. It can serve as our security. What do I mean by security? This committee, according to legislation, is required to make recommendations for changes to the Act or any enactments to the Commission. The committee shall also make recommendations for the development and reform of company law in Anguilla, and finally to ensure that the ABC Act remains relevant to the company law. This committee calls for ongoing communication between the minister, the registrar, and the commission. Another important benefit is that the ABC legislation cannot be successful without having a system tailored to its many offerings. Right now, we refer to that system as Quest. While another forum will be provided to further share with you an update on the new system, I can tell you that this new system was designed to address the shortfalls of the current Acorn system. It will host data for economic substance reporting and beneficial ownership. It allows for attachments to be uploaded and an overall greater flexibility and less reliance or input from the registry as it pertains to certain filings. In addition, other benefits will include, as Theo said earlier, electronic signatures. And this, I believe, is very important given the time that we are in, where persons cannot meet physically. So work is able to be continued with the legislation making provision for electronic signatures as well as smart contracts, as I said earlier. Also, more time is given for agents to comfortable retain a new agent. So there's a lot of benefit from the ABC Act, and it's not just about mouth any longer, but it actually has legislative support, and I believe it will do great wonders for this industry and Anguilla on a whole. So as I close, let me take this opportunity to thank those who have provided valuable input thus far as it relates to the public consultations, and I will further encourage you to keep on doing so. The registry looks forward to serving you in this new chapter. Thank you so much for listening.
Thank you, Micheline. We will now turn to Ms. Tina Bryan, Director of the FSC, who will give us a brief overview of the Segregated Portfolios Companies component.
Thank you, Marissa, and good morning and good evening to all that are listening. The draft Anguilla Business Companies legislation contains provisions that allow for the incorporation of a segregated portfolio company in which written permission is required from the Commission. The Segregated Portfolio Company, or SPC, is a separate legal company that has segregated portfolios which are not separate legal entities. The segregated portfolio company segregates the assets and liabilities of each segregated portfolio and segregate those actually from the assets and liabilities of each segregated portfolio as well as from the general assets of the SPC. Thus, the assets of the segregated portfolio are available to meet the liabilities in respect of that specific segregated portfolio and not that of the other segregated portfolios or the general account. Now, the SPCs exist in various jurisdictions to include Guernsey, Bermuda, Cayman Islands, and the BVI. In most cases, these companies conduct business in insurance and mutual funds. The draft ABC regulation sets out the purpose for which the Anguilla Business Companies SPC can be used, and this includes holding assets for high net worth persons, including institutional investors, operating multiple business structures or types of businesses which require segregation from the business of the segregated portfolio company. Also engaging in property development and management, generally dealing in real estate, ships, aircrafts, and other property which the company considered will be more efficient and cost-effective to set up via an SPC. Now, the key feature of an SPC structure is that it allows for a statutory segregation of portfolios under one company, which could have only been achieved by establishing subsidiaries or other structures. So the general belief is that the SPC structure allows for greater flexibilities and efficiencies, and according to a 2019 Conyers publication, this structure allows for the pooling of professional support and results in more robust asset and liability protection. Now, as you are aware, there is the Protected Cell Companies legislation currently in place in Anguilla. Now, the PCC structure has not really taken off, and it is hoped that the Anguilla Business Companies SPCs will revive interest in these type of companies, allowing us basically to incorporate more of those particular structures and grow the industry. Thank you.
Thank you, Tina. And I now, I must unfortunately apologize for the absence of two of our members of the ad hoc committee, Mrs. Kentish Egan and Mr. Ravi Badasingh. Unfortunately, they had urgent commitments that they were unavailable to attend this morning's session. I now at this point invite comments on the industry perspective from the ad hoc committee industry members online with us. Mr. Alwyn de Coker and Professor Alwyn de Coker, any comments?
Unmute, please.
One moment, Professor. We're just. You need to unmute yourself.
Okay, is that better?
Yes, thank you.
Okay. Distinguished participants, in affirmation of the previous speakers, I should start off by saying that the global environment has changed dramatically in the last 2 decades. The major driving force being the pressure of globalization and the striking developments in financial markets and modern technology. Many old concepts have been abandoned or modified. We live in a world of increased electronic communication, greater sensitivity to social and ethical concerns, and greater competition for capital, for goods, and for services. Moreover, there is a growing recognition by investors and indeed governments who demand higher standards of corporate governance and ethics, and greater interdependence between enterprises and the societies in which they operate. I would submit that Anguilla cannot afford to be left behind. Hence, our new company law attempts to reflect these changes, since good law can create a protective and productive environment for economic activity. Company law is therefore a major objective. The new Anguilla Business Companies Act, I would state, has modernized the law and brought it into line with international best practices. The broad objectives of the Act can be summarized as follows. It's an attempt to promote and continue to promote the development of the financial services sector in Anguilla by firstly providing a framework for the efficient regulation of companies without sacrificing Anguilla's international competitiveness. Secondly, maintaining flexibility and relative simplicity in the formation and maintenance of companies. Thirdly, encouraging transparency, accountability, and high standards of corporate governance, appropriate in a manner that enhances the economic welfare of Anguilla as a partner within the global economy. And also, finally, effective ethical leadership based on good ethics to protect the interests of the company, its stakeholders, especially minority shareholders, as well as citizens, the community, and society at large. How do we protect, for example, the interests of stakeholders and the community? By way of background, the doctrine of capital maintenance forbids a corporation to return capital to its shareholders, essentially for the protection of creditors and the discharge of its liabilities, unless such return is authorized by law, such as, for example, a sanctioned reduction of capital. In other words, only profits may be distributed to the shareholders. The doctrine of capital maintenance underpins the legal rules relating to inter alia, the payment of dividends or other distributions to shareholders, the reduction of a company's share capital and reserves, and the prohibition of financial assistance by a company for the purchase of its shares. But in numerous countries over the last 2 decades, the doctrine of capital maintenance has been abolished. One of the reasons being that companies are and were permitted to pay dividends from circulating capital surpluses, even though overall there were losses of total invested capital. In contradistinction and consistent with international norms, the new Anguilla Act is posited on the concept of solvency and liquidity, the objective of which is to ensure that stakeholders of the company are not prejudiced by transactions which have the effect of eroding the value of the company to the benefit of a select group of people. The solvency-based threshold thus guard against short-term opportunistic or abusive distributions out of corporate capital. This test requires two different types of solvency. In other words, firstly, factual solvency, and secondly, commercial solvency. And the test in the new act is stated in the positive rather than the negative. Factual solvency is purely a balance sheet test that is at a particular moment. The test is thus based on the integrity of the financial reporting standards underpinning its preparation. What about commercial solvency, the second leg? Commercial solvency in respect of liquidity is based on reasonably foreseeable financial circumstances. That is to say that the company will be able to pay its debts as they fall due. From a commercial perspective, the true test of the solvency test is not whether the company's liabilities exceed its assets, but whether it is able to pay its debts. In the case of factual insolvency, the first test, it requires a comparison of present assets with present and future liabilities, the latter having been discounted to account for contingencies and deferment of payments. This becomes an essential test, though it is still very far from an exact one. It is for the party asserting balance sheet insolvency to establish insolvency of that nature. But this test is a very positive development in our act, which is known as the new Anguilla Business Companies Act, as we know. Secondly, and lastly, I'd like to talk very briefly about another feature of the new act, which revolves around economic substance. The introduction of economic substance requirements in a number of offshore jurisdictions, not excluding Anguilla, means that the doctrine of economic substance and its relationship to company law has become increasingly important. Insofar as the legal framework is concerned, Anguilla has implemented legislation to address the concerns of the EU Code of Conduct Group to ensure that Anguilla companies cannot be used to artificially attract profits that are not commensurate with economic activities and substantial economic presence in Anguilla. But that is not all. The conceptual framework of the new act in Part 8 not only makes mention of the economic substance legislation, but complements it by setting out the mandatory reporting requirements. It also makes deals with the question of attorney-client professional privilege. In other words, it also deals with the question of attorney-client professional privilege, referred to normally as attorney-client privilege. Those are the main features of the Act. I think that everybody concerned in the Ministry of Finance, the Financial Services Commission, the Commercial Registry, Inland Revenue, Anguilla Finance, and the work that was put in by various people in Anguilla has been remarkable, and I think that we see the fruit of their work in the form of this new act. Thank you very much.
Thank you, Professor Alwyn. I now invite Robert, if you have any remarks or perspectives to share.
Well, thank you very much for the opportunity to say something as well. But actually, I can fully endorse the words of Professor De Koker and also well, everybody on the committee and the commission. I believe that yeah, with this law, Anguilla is entering a new era, new phase, and really will be part of the selected group of jurisdictions which has fully compliant law with respect to offshore companies. And I'm actually very pleased to see the results so far. But as already stated, a lot of things have been mentioned already during previous meetings, and I believe that with the final result, it's something that we can be very pleased with. And I would like to congratulate everybody involved in creating this law. Thank you very much.
Thank you, Robert. We now come to the section where we open the floor, well, open the chat box for any questions. So I invite any comments, clarifications, questions, anything. This is your time to share your thoughts and propose any solutions.
I just want to note that there was quite a bit of comments that came in from the industry. It was quite comprehensive in terms of covering the various provisions. I think based on what I've read, I think what was key for some persons, and maybe the other members of the committee can probably speak to that as well. I think the key concern was really in terms of any possible transitions, given that there may be a couple new elements to work out. I think that's the impression I'm getting in terms of the majority of the concerns. The other comments, more or less, were such that may have to be worked with in terms of further research and being able to make policy decisions on. But generally speaking, from what we've seen, is that there was some concern about possibly a transition period that was comfortable for everyone in order to allow for that smooth transition.
Okay, we're still monitoring the chat box for any questions. We don't have any at this time, but at this time I would like to invite anyone around the table who has any comments to make. Any final comments?
Maybe, Ms. Conner, if I can just say one or two words in conclusion. I think that the industry participants and the various people from Anguilla in the Ministry of Finance, the FSC, the Commercial Registry, Inland Revenue, Anguilla Finance, etc., can be very proud of this act. I see a lot of good that comes forth when one reads it. And I also see this particular act as a springboard for developments as we go along. Because we are in a world now that develops very quickly economically. New vehicles, new concepts, new financial instruments. And we should strive to keep abreast of all developments because one can't be left behind in this world. And I think we have the platform to do so. So it is a very exciting time. And I think that Anguilla and all of you present can be very proud of what you've achieved. So I must congratulate you. Thank you very much.
Just want to draw your attention to the publications on the Government of Anguilla website, as well as to the Anguilla Financial Services Commission website and the Commercial Registry, where the various drafts have been published, various drafts of the bill, as well as the regulations, as well as the comments. I think persons should take the time to review the various comments and their responses to the comments, and to be able to provide further responses as well. So if you haven't done so as yet, please do so. I think it will be very beneficial.
Thank you, Professor Alwyn, for those final comments, and thank you, Tina, for that instructive directions as it pertains to documents related to the public consultation. As my colleague has informed me that there's no further comments at this time, I think we have been very clear, well, we hope we have been very clear and informative in our presentations. And I would like to thank you, the listening audience, for joining us for this public consultation and for your comments. I know some of you listening would have submitted written comments in both rounds of the consultations. At this time, we will now draw to a close. Thank you once again for attending. And yes, you can. What is the mailbox for the questions? What mailbox are we using? For the consultation, what mailbox?
Basically for the Shireen books.
Yes. If you do happen to have any comments or questions after we come offline, you can send them to Shireen.Brooks at afsc.ai. That's Shireen, SHERINE.BROOKS at Anguilla, afsc.ai. We thank you once again for joining us, and we wish you a good day.